Legal Pond.
Welcome to today's episode of the Legal Pond. Today's episode is going to be on remedies for breach of contract. And the particular remedy we are going to focus on in this video is damages. Let's get started.
The Legal Pond.
Welcome back. As I said early on, today's episode is going to be on remedies for breach of contract. And then we are going to look at damages as a remedy for breach of contract. Now, whenever the parties enters into a contract and there is a breach, the innocent party, the party who is not at fault, is supposed to be remedied. And some of the remedies available to the innocent party are damages, which is from common law, and equitable remedies such as specific performance, injunction, rescission, rectification, among others. Now, this video is going to focus on damages, which is the original remedy for breach of contract as developed by common law. Now, what is damages? Damages is a monetary compensation given to an innocent party after the breach of a contract. It is a monetary compensation given to an innocent party after the breach of contract. So after a contract has been breached, the innocent party may have suffered a number of injuries. It can be personal injuries, it can be injuries to property, it can be loss of benefit or loss of potential benefit. It can be reliance expenditure. In fact, the innocent party may suffer different kinds of injuries. Now, in all these, the court awards damages to compensate the innocent party. Now, what is the purpose of damages? In the case of Fairley versus Skinner, Lord's Court mentioned that the reason why the court grants damages is not to punish the breaching party, but to place the innocent party in a position he would have been had the contract not been breached. So the purpose of damages is to place the innocent party in a position he would have been had the contract not been breached or had the contract been performed. So if but for the breach, the innocent party would have made 10,000 Ghana cedis, then the court must compensate him to put him in a position where he would get that 10,000 Ghana cedis. The same purpose was repeated in the case of Robinson versus Harman. You may also look at the case of Royal Dutch Airline versus Pharmax. So these are authorities that tells us that the court does not grant damages just to punish, but rather to put the innocent party in a position he would have been had the contract been performed. Now, what are the types of damages that may be claimed by the innocent party after the breach? Now, there are two major types of damages, which are liquidated damages and unliquidated damages. Now, what are liquidated damages? And at what point will the court grant liquidated damages? Now, liquidated damages is a damage which is assessed based on the contractual price fixed by the parties. So liquidated damages are actually calculated by the parties and fixed as a term in the contract. So once there is a breach, the breaching party will pay that amount as calculated by the parties themselves. Now, such monies or such damages as assessed by the parties themselves are not punitive in nature, as was mentioned in the case of Cavendish Square Holdings versus Total EL. However, if the parties insert a liquidated sum in the contract as the liquidated damage, and that liquidated sum being inserted is punitive in nature, then it changes from being a liquidated damages into what you call a penalty clause, and the court will not enforce a penalty clause. So in the case of Dunlop Pneumatic Tire versus New Garage Motors, the court said that for the court to be able to see that a particular clause which is stated in a contract is a penalty clause, there are some characteristics that it has. One of them is that that clause is extravagant in nature, or sometimes a lump sum is stated to affect both serious and trivial breaches. Such a clause, such an amount being stated becomes a penalty clause. Another characteristic is that a penalty clause may cover secondary obligations, obligations that do not flow directly under the contract. The clause may cover it. When we see these characteristics surrounding a supposed liquidated clause being stated in the contract, then it will be considered as a penalty clause because it is meant to punish and not meant to compensate. And because of that, the court will not enforce it. Then we have unliquidated damages. Now, for unliquidated damages, they are not fixed by the parties themselves. These kind of damages are left to the court to decide the quantum. And examples of such unliquidated damages are general damages, special damages, exemplary damages, nominal damages, among others. Now, for the court to grant a particular unliquidated damage, the court applies two tests, which will help them determine whether that damage is claimable or not. There are two tests that comes to play. The first test that the court applies is what we call the test of remoteness of damages. Then the second test applied by the court is the test of mitigation. So for the court to grant that damages, the court must go through these two tests. Now, what is the test of remoteness? How does it operate? What are the principles regarding the remoteness test? After looking at that one, we will look at the test of mitigation and the rules regarding it. Now, the test of remoteness is to the effect that the parties to a contract can only claim damages which are not too far from the breach. So for the court to grant damages, whether special, whether general, whether nominal, that damages should not be too remote from the breach that has happened. Now, in doing that, in using the test, the court uses what you call reasonable foreseeability test. The injury that has happened, the damage that has arisen, is this something that was reasonably foreseeable? Now, to know that the damage is reasonably foreseeable from the breach, there are two major kind of damages that are looked at here. Now, the court has one kind of damage called general damages. Now, general damages are ones that flows naturally from the breach. So if I ask you to supply me with a laptop and you fail to supply me with the laptop, the natural consequence is that I may not have the laptop to do what I want to do. So you must pay me for general damages. That is an injury flowing naturally from the breach. Then we have ones that are called special damages. With special damages, the court relies on the relative knowledge of the parties to see whether the injury is reasonably foreseeable. So in the case of Hadley versus Baxendale, the court said that it will only grant damages that flows directly from the breach of the contract, and that type of damages is called general damages. But for special damages, for the court to grant special damages, that particular injury which gave rise to that damages must be an injury that was within the reasonable contemplation of the parties at the time of making the contract. And for the court to grant such special damages, then the special circumstances of that party which led to that special injury must be known to the breaching party, must be in the contemplation of the breaching party. So for instance, you were supposed to supply me with a laptop. You failed to supply the laptop. Now, you knew very well that I needed the laptop to develop a software for a company for an amount worth over $100,000. Now, because you were aware of that special circumstance that if you fail to supply, I will lose that contract, then you will pay the general damages for not supplying the laptop. And two, you will pay special damages for the losses I have incurred or the loss of profit that I have made as a result of you not supplying the laptop. So the test used to be that for the court to grant special damages, then the special circumstances of the claimant must have been in the contemplation of the defendant at the time of making the contract. Then there is another case that came, the case of Victoria Laundry Limited versus Newman Industries Limited, where the court said, sometimes for actual knowledge of the special circumstances of the plaintiff, the defendant should know, taking into consideration the position of the defendant. So sometimes, because of what you do, because the thing that you are supplying is your work, because you have expertise in the field, you are deemed to know the special circumstances of the defendant. And in that sense, we say that you need not to be given actual notice. The notice will be imputed. So the Victoria Laundry case came to modify the rule as was propounded in Hadley versus Baxendale. So in summary, for the court to grant general damages, that general damages must have flown naturally from the breach of the contract. for the court to grant special damages, then that special damages must have been brought to the actual notice of the breaching party. That is, the special circumstances leading to that special damages must have been brought to the actual notice of the breaching party. Or the circumstances should be that that particular breaching party is in a position which charges him to know of the special circumstances of the defendant. His position will make that knowledge be imputed. So you may consider the cases of Frafra versus Boache and the case of Jackson Smith versus KLM Dutch Airlines. You may look at these two cases, then they will give you more insight to the test of remoteness. The second test that the court applies in granting that unliquidated damages is the test of mitigation. Now, this test of mitigation is to the effect that the innocent party is placed under duty to take reasonable steps to reduce the losses after the breach. So if after the breach, there were certain things that the innocent party could have done to reduce the losses that has happened, and he failed to do it, he cannot claim damages for losses that could have been mitigated. So the fact that there is a breach does not mean that every loss arising out of the breach should be paid. If the loss could have been mitigated and the innocent party failed to mitigate it, he cannot claim damages for those losses that could have been mitigated. And this was demonstrated in the case of Peso Limited versus Saunders, where the plaintiff had contracted to buy some goods from the defendant. And then it was such that anytime he orders and it is supplied, then he pays. Now, at a point in time, the buyer had some challenges with his bank account, and the seller mistakenly believed that the plaintiff was in financial difficulty, told him that this time you must give me cash before I supply. And because of that, the plaintiff went to buy from town and sued the defendant for breach. But the court said that you could have accepted it and sue for the difference rather than going to buy it in the market at a higher price. You did not mitigate the loss, and because of that, you cannot claim damages for that loss. It must, however, be noted that the fact that the claimant must mitigate the losses does not mean he must take risk or complicated task. If the duty of mitigating the loss will cause risk, will cause too much damage, then the plaintiff is not bound to take those risks. So if it happens that the plaintiff did not mitigate the loss and he has sued, and you are asking, or you the defendant, you are saying that the plaintiff did not mitigate, the plaintiff can say that I wanted to mitigate, but if I try to mitigate, the risk is higher than me not mitigating it. So the law is that the plaintiff is not under duty to mitigate when mitigation comes with a higher risk or a complicated task. You may see that in the case of Pilkington versus Wood. And in that same case, the court said that if the party successfully mitigates the losses, then expenses that he incurred in mitigating the losses, reasonable expenses that he incurred in mitigating the losses, can be claimed as part of the damages. We must also know this. In granting unliquidated damages, the court can grant what we call reliance damage. Now, reliance damage is damages which is given to the innocent party for expenses he made in preparation to perform the contract. So, for example, I contracted with Mr. A for Mr. A to supply me with a car. I have paid, but Mr. A has failed to supply the car. Meanwhile, because I was expecting him to supply the car, I went to build a garage. I spent money to build a garage in my effort to receive the car. Now, if Mr. A breaches the contract and I am claiming damages, I can claim what we call reliance damage. I relied on his part of the contract to incur expenses, and I can claim that as reliance damage, and such a damage is unliquidated. It is the court that will determine. This was noted in Angler Television Limited versus Reed. Again, we must know that when a party suffers non-economic losses, generally, the law used to be that the court shall not grant damages for non-economic losses. For example, personal injury. As a result of the breach of the contract, you suffered a body injury. The law of contract does not grant it. So in the case of Addis versus Gramophone, the court did not grant damages for personal injury. But going forward, the case of Jarvis versus Swan Tours Limited came to hold that if the non-economic loss is not too removed from the breach, the court can grant it, because in Addis versus Gramophone, the court did not really give any authority for not granting non-economic losses. So since they have no proper legal backing to that rule, the court will grant damages for non-economic losses, provided that particular non-economic loss is not too remote from the breach. So basically, these are the simple rules regarding the grant of damages, being it liquidated or unliquidated, being it special or general. These are the principles that governs how the court grants damages after breach of contract. If you have any question, you can drop it in the comment section for an assistance to be given, or you can contact the number on the screen and then channel your concern so that we address it accordingly. I advise that you get the legal companion as well, and then look at the questions and answers on remedies for breach of contract. See you in our next video.
The Legal Pond.